All right. It is 4 o'clock, and I am going to call this session of the Washington History Seminar to order. I want to welcome everyone to this seminar, subtitled Historical Perspectives on International and National Affairs. This afternoon, we will be focusing on a new book by the Princeton historian Laura Edwards, titled Only the Clothes on Her Back, Clothing and the Hidden History of Power in the 19th Century United States, published by Oxford University Press in late February. And joining us this afternoon as discussants are Martha Jones of Johns Hopkins and Megan Sweeney of the University of Michigan. I'm Eric Arneson from the George Washington University, co-chair of the Washington History Seminar, along with my colleague Christian Osterman of the Wilson Center, who cannot be here today. The Washington History Seminar is a collaborative, nonpartisan venture of the Woodrow Wilson Center's History and Public Policy Program and the American Historical Association's National History Center. And for over the past decade, the seminar has been meeting weekly in pre-COVID times in person at the Wilson Center, and since the pandemic, well, here in the virtual realm. Behind the scenes, two people make these seminars possible: Pete Bierstecker of the Wilson Center and Rachel Wheatley of the National History Center. And I'd like to thank institutional supporters, the George Washington University Department of History in particular, as well as a number of anonymous individual donors. And as I say, every week, we invite you to join their ranks. On the logistics front, please note, today's session is being recorded and can soon be found on our institution's respective websites. And crucially, when we get to the question and answer section of the webinar, we ask those with questions to use the raise hand function on Zoom or the Q&A function, not chat. And to those watching on Facebook Live, you can email questions to Rachel Wheatley at rwheatley, RWHEATLEY, @historians.org. And we will call on as many folks as we can. We prefer for you to raise hand and pose the question yourself. Otherwise, I have to pose it for you. All right, with that, it is my pleasure to introduce our speaker this afternoon, Laura Edwards, who is the class of 1921 bicentennial professor in the history of American law and liberty in the history department at Princeton University. Her work focuses on the legal history of the 19th century United States, with an emphasis on people's interactions with the law and the legal system. She's the author of a number of books: A Legal History of the Civil War and Reconstruction, A Nation of Rights, published in 2015, and The People and Their Peace, Legal Culture and the Transformation of Inequality in the Post-Revolutionary South, 2009. A book that was awarded the American Historical Association's Littleton Griswold Prize for the best book in law and society, and the Southern Historical Association's Charles Sidner Prize for the best book in Southern history. She's received fellowships from the Newberry Library, the National Humanities Center, the National Endowment for the Humanities, the ACLS, the Guggenheim Foundation, and the American Bar Foundation. And today, we're delighted that she's here speaking about her most recent book, Only the Clothes on Her Back, Clothing and the Hidden History of Power in the 19th Century United States. Laura, the screen is all yours. Welcome to the Washington History Seminar.
Thank you so much for having me, and thank you for the lovely introduction, and thank you to Megan and Martha for coming today as well. So I'm going to start with a story because the book is full of stories. So I'm going to begin with 6 Women and a Sheet. So all of these women and the sheet appeared in New York City's municipal court in 1804. And actually, it was the sheet that started it all, which is apropos because this book is about textiles. So one of the women, Sarah Allingham, charged another woman, Judith Friel, with stealing the sheet, although these charges really vastly oversimplified this whole situation. So Judith Friel was a washerwoman who just happened to have the sheet amongst the dirty laundry she was collecting that day. So imagine her consternation where Sarah Allingham ran out into the street, waylaid her, grabbed up her bundles, and began rummaging through them in the city streets, loudly, actually rummaging through them. So when Allingham found what she insisted was her sheet, she announced her discovery and marched off with it to file charges in the New York City's mayor's court. And Judith Friel was following in her wake. So once in court, it became clear that Judith Friel was in fact merely transporting that sheet to her house to be washed. It was another woman, Sally Riley, who had taken it nearly a year earlier. So Riley had then sold it to Rosanna Morara, this is getting confusing, whose bundle of laundry was the one that contained the sheet. So both of those women joined the other two, making 4 women and a sheet in court. Then 2 more women appeared as witnesses to support Rosanna Morara's claims that she had purchased the sheet from Sally Riley, bringing us to 6 women and a sheet. So ultimately, the court listened to all this. They awarded the sheet to Rosanna Morara. So case closed. But actually, not really. Robert, given conventional historical wisdom, this dispute never really should have made it to court at all. These were poor women, they're squabbling over a cheap sheet, and more to the point, they were married women encumbered by coverture, a collection of legal principles that limited wives' legal rights and subordinated them to their husbands. Among other things, coverture prohibited women from owning property and prosecuting court cases in their own name. More than that, coverture gave husbands legal rights to property in their wives and property that their wives brought into marriage and anything that they acquired afterward. By those rules, Sarah Allingham could not own a sheet, let alone prosecute a case to claim ownership. Yet in Sarah Allingham's case, officials accepted both the women's claims to property and their access to the legal system. They did ultimately give a nod to coverture's rules. They identified the prosecutor as Allingham's husband, attributing ownership of the sheet to him. But after filling in the obligatory boxes, officials dispensed with this fiction that the matter had anything to do with the husbands. In fact, they were not in court at all. For the court officials, as well as the women involved, the question was which married woman possessed the sheet, not whether a married woman could possess it. Now, to make things more interesting here, this case was not at all unusual. Between the Revolution and the Civil War, courts in the United States regularly dealt with similar cases involving claims by people on the legal margins, often people without property rights at all, to clothing, related accessories such as hats and handkerchiefs, as well as uncut cloth and bed linens. So how could people without property rights claim property? And that is the question that I explore in this book, Only the Clothes on Her Back. The answers, I argue, lie in the legal qualities that attach to clothing. So people without property rights, including married women and enslaved people, relied on long-standing legal principles that attach clothing to the person who wore it. But they did not stop there. Through use, they expanded those legal principles to make legal claims to all kinds of textiles and accessories that they made or that simply passed through their hands. Because it was textiles and something related to cloth, they could keep this. They could make legal claims to it. And then they went further, using the security provided by law to turn these goods into currency, into capital and collateral for credit, which gave them an entry point into governing institutions and the economy. People like Sarah Allingham were not on the outside looking in, as we have usually assumed. They actually used textiles to include themselves in governing institutions and the economy. And they really made law this way, insisting on the recognition of commonly held legal principles that, unlike property rights, applied broadly to everyone. So the fuss over Sarah Allingham's sheet was not really that unusual. Once you start looking for textiles, you realize that they're everywhere. People made them, they sold them, they talked about them, they fought about them all the time. Yet scholars from this period, the period between the Revolution and the Civil War, have tended to kind of walk by such property and assume that it was more like consumer goods, and instead focus on the kind of property, land, enslaved property, commodities owned by elite white men, the minority of the population. But textiles in this period were not just consumer goods. They too were valuable property, and valuable property that, unlike other forms of property, most Americans could legally own. So by the time of the Revolution, the economics of textiles had hit really a kind of a sweet spot. What had been luxury goods before were now more affordable and more available, and not so cheap as to be completely worthless. Quality mattered, and people knew quality. A broad range of Americans, including the poor and enslaved, could spot fine linen, silk, wool at 10 paces, and they could assess trimming such as ribbon and braid just as accurately. And that knowledge was on prominent display in theft cases across the United States. Parties to these cases would describe cloth and clothing in great detail, distinguishing cheap goods from expensive ones and rattling off information about fiber content, colors, and patterns that most people today would never notice, let alone remember. And all the details function like figures on a banknote, actually. In fact, textiles were preferable to banknotes for many Americans. The possession of banknotes was suspect for poor people and people without property rights. The presumption was that they should not have them, and so if they did, it was suspicious. But not so with the possession of textiles, because the legal principles associated with them gave people claims to them. Textiles also had economic advantages over banknotes because they actually held their value more reliably. The material qualities of textiles suited them for use as currency as well. There was considerable consensus as to their value. They were extremely liquid, and they came in different denominations, which was handy. They ran the gamut from handkerchiefs, which you could use to buy small things, and big, expensive lengths of cloth, which you could use to buy more expensive things. When people traded in these goods, they were not bartering. They valued items in pounds or dollars and then bought and sold accordingly and leveraged the value of textiles as people did with other property, pawning them, lending them, or saving them to fund future ventures. The result was this vast secondary market, which provided not just access to goods, but also a means to circulate them. So this part of the market was kind of everywhere and nowhere in particular. It included pawnbrokers, auctioneers, peddlers, grocers, tavern keepers, tailors, dressmakers, unlicensed shopkeepers, vendors in open air markets, as well as individuals who just sold on the streets and from their homes. And to say that this market was underground or informal actually misconstrues its institutional underpinnings, which depended on widely recognized enforced rules. Ownership was established through relationship to the goods as witnessed by other people, through possession, through use and display. Wearing was a really good way to establish ownership. So was buying and selling in public. And Sarah Allingham ultimately lost her sheet to Rosanna Marrara because Rosanna Marrara had exactly the kind of evidence that proved possession and took the place of the information on her receipt. She had witnesses who could describe the property and value it, connect it to the purported owner, provide the date of purchase, verify the transaction, and she actually had the sheet in her possession. There were also rules for exchange. People pawned cloth if they wanted it back. They loaned it if they did not. In pawning, people used clothing and other textiles as collateral against which they borrowed, paying fees, which was interest each week. People charged with theft actually would point out that they had pawned the goods, which meant they didn't steal them because they could always get them back. They had not yet reduced them to their possession. But loans were different. With loans, the owner expected the return of the textile's value plus interest, not the goods themselves, which declined in value and use over time. Nobody wants the handkerchief that somebody else blew their nose in back. So the terms were then agreed to at the time of the loan verbally. And this is actually what Sarah Allingham's case was all about. The testimony suggests that she had actually loaned the sheet to her neighbor, Sally Riley, not because Riley was in desperate need of bed linens, but because both women were leveraging the sheet's value. Riley then sold it to Rosanna Marrara, which was accepted practice and did not negate her obligation to repay the value of the sheet. It was only after Allingham believed that Riley had reneged on the loan that she took matters into her own hand and seized the sheet, hoping to recoup some of her loss. Then she went to court because it was never just about the sheet. The rules of exchange really mattered. Those expectations of enforcement ran deep and kept local courts in both rural and urban areas very, very busy. It is really remarkable that people without property rights felt confident in pursuing cases that looked an awful lot like assertions of property rights. Even more remarkable is the response of local officials who dutifully sorted through the evidence involving sheets, shifts, handkerchiefs, shirts, and shoes to figure out whose property was whose. The legal qualities of textiles, though, only went so far, and the book traces the trajectory of their use, their rise, their use, and decline over time. People without property rights could not make claims through civil actions, the usual means of reclaiming property through debt cases, for instance, because such suits required the possession of rights. Even people with rights, but on the legal margins because of race and class, found civil actions difficult because they did not have the resources and the kinds of evidence necessary to pursue them. So officials then shifted claims to public law, where they could be tried as criminal offenses, usually theft. The point in this area of law was to right wrongs, to put things back where they belong, to make things right, and that included sheets. So in this body of law, court officials could act on complaints by people without the rights necessary in civil cases by treating these matters as things involving the public order. So they're a violation of the public order, not a violation of their individual rights. Matters involving claims to textiles also fit really well within this area of law because the legal principles that allowed everyone to own and trade these goods were so well established and established through practice as part of the public order. Prosecution affirmed those practices and restored the property to the places where they belonged without recognizing the rights of the individuals involved. Now, this provided some flexibility for people to make legal claims, but it also came with real costs. The legal charge, theft, was a convenience, but it made the varied property claims of people without strong claims to property rights, it made all of those claims to property different, and it made them also seem illegitimate. In fact, it criminalized them. Somebody could own the property, but another person was declared a criminal. The implications, while ominous in the decades following the revolution, would become inescapable as mid-century approached, and the balance of legal authority started shifting towards those areas of law that focused more on the rights of individuals. Now, rights had definite advantages over textiles, where claims to textiles stayed in particular contexts with the people who knew about them, the people who could testify about them, the people who could show that they owned them. Rights-based claims to property traveled freely. If individuals had rights, they could claim property across all the mess of jurisdictional lines in the federal system, within states, from state to state, from states to territories, and pretty much in all bodies of law as well. Now, this kind of portability mattered in a world where people moved and goods also flowed freely. In fact, rights, particularly property rights, were this rare constant across all the jurisdictional lines of local, state, and federal. But that situation was challenging for merchants who were working across all of these jurisdictional lines. And so they needed some sort of constant that allowed them to do business and do this, make similar kinds of claims across these jurisdictional lines. But the problems were also more fundamental here. So all of these laws, all of these jurisdictions determined a person's status and how they could move through the world. So people of African descent, notably, were presumed to be enslaved in some states and free in others. So this is the problem. No wonder then that the elimination of all of these restrictions on rights, particularly property rights, became key political issues for women, for African Americans in the decades leading up to the Civil War. Rights are the things that allow people status also to have constancy across all this massive jurisdictional lines. The problem, though, was that the extension of rights did not allow for the kind of claims made with textiles, nor did they eliminate the other legal restrictions that kept all women, many African Americans, and even poor white men from claiming and using rights. Textiles had given these people legal cover, but without them, they were vulnerable. Now, to be sure, the extension of rights helped. In fact, it was impossible to navigate either the legal order or the economy without them. But the possession of rights only went so far, as long as other kinds of restrictions remained in place. So by the late 19th century, actually, as the book argues, many Americans had little more than the clothes on their backs, but that property had become pretty flimsy legal coverings by then. And the people on the legal margins, though, and this is, I think, really the point of the book, did not just wait around for rights to be extended to them. They used the legal materials they had at hand throughout the 19th century to work toward a world where they could claim their labor, possess property, and define their own destinies. And those legal materials were literally the clothes on their backs.
Thank you very much, Laura Edwards. Our first discussant this afternoon is Professor Martha S. Jones, who is the Society of Black Alumni Presidential Professor, Professor of History, and a professor at the SNF Agora Institute at the Johns Hopkins University. She is a legal and cultural historian whose work examines how Black Americans have shaped the story of American democracy. Professor Jones is the author of Vanguard, How Black Women Broke Barriers, Won the Vote, and Insisted on Equality for All, published in 2020, and was selected as one of Time's 100 must-read books for that year. She is also the author of the award-winning Birthright Citizens, A History of Race and Rights in Antebellum America, published in 2018, All Bound Up Together, The Woman Question in African American Public Culture, 1830 to 1900, published in 2007, and she's co-editor of Toward an Intellectual History of Black Women, published in 2015. Prior to her academic career, she was a public interest litigator in New York City, and she currently serves on the boards of the Society of American Historians, the National Women's History Museum, the U.S. Capitol Historical Society, the Johns Hopkins University Press, the Journal of African American History, and Slavery and Abolition. Professor Jones, Martha, welcome to the seminar. The screen is yours.
Thanks very much, Eric. Thank you to the Washington History Seminar and the AHA and the Wilson Center for convening us today. I wanted to start by saying I very distinctly remember when I said almost simultaneously to Laura Edwards and to Megan Sweeney both that they had to meet one another. They had to trade notes. Here were these two extraordinary scholars with such deep engagement and commitment to the craft and to the culture and to the everyday life of textiles, even in their own lives. That means that this afternoon, I'm a bit of a happy interloper. I can barely thread a needle, and I need to read the label to distinguish between rayon and silk. And still, from both of you, I've learned so much about my own archives and the women who I have encountered there, pilfering and thieving and secreting and snatching and otherwise claiming fabric and clothes that were not their own. If in local courthouses, these were women deemed petty thieves, and on occasion, actually not so petty, it was in conversation with Laura Edwards and through her work that has become this magnificent book, Only the Clothes on Her Back, that I was required to return to those archives and read them anew. So thank you, Laura, for the book, for your mentorship, and for your example. It has been truly transformative in my work. So when I say this book is much anticipated, well, that's an understatement, I guess. But many of us have been treated to parts of this work over the years at conferences and workshops and through comments on panels, all of which suggested the degree to which this would be path-breaking. And so here we are to offer congratulations and some comment. One of the things that's remarkable about this book is the degree to which historians of capitalism, of early America's many legalities, along with historians of textiles trade, the economic lives of women, and more, will be fascinated and changed by this study. Laura Edwards has brought her vast and field-defining expertise on the quotidian and yet profoundly consequential dynamics of local legal culture into conversation with the far-reaching, even global dynamics that defined the production, trade, and the market of textiles in early America. These latter, what in my work might be abstract matters, might cause the eyes of cultural historians like me to glaze over. But Laura Edwards, of course, has stories, as you've already heard this afternoon. One of the strengths of this work is its insistence and its deep capacity to bear out the claim that local people, ordinary Americans, even those marginalized in formal law, were connected to global markets and changed market forces in their own lives and by their own terms. It's a work that takes us back to Dylan Penningroth's important and enduring claims of kinfolk. As I read this again, I remembered these are histories that take new and even unorthodox points of view that change our thinking. No longer are ordinary people merely those buffeted about by capitalism's market forces. They are agents of law and lawmaking. And while Laura might see it otherwise, for me, this is the best of the approach to legal history pioneered by folks like Dirk Hartog and exemplified in his article, Pigs and Positivism, now many decades ago. The law was what people, even ordinary people, made it out to be. It was the contests that they waged, the debates they weighed in on, all that, rather than the text alone, is for us the history of law. One of the things I think readers might not anticipate is how this book is also an elegant primer in the history of fabrics and textiles, their crafting, production, styling, and more. Such an insider's perspective could require a glossary in a less well-written book, But here, the value of textiles comes plain as we learn what it took to render them as articles of practical adornment, pretentious beauty, and even class and status. This foundation is what permits us to accept how such materials also became economic instruments, currency, capital, and credit. Any historian who has read a will or estate inventory has noted a family squabble over garments and fabric, or like me, marveled at how many cases on a 19th century local courthouse criminal docket mentioned the theft of textiles and clothes by someone who had no apparent use for them, finally has an answer to the questions these archives present. As Laura Edwards explains, these items were property unlike any other, and their value extended far beyond how they adorned oneself, one's dependents, or one's home. Textiles were property of a distinct sort, so much so that even Americans shunted to the margins of legal culture could claim their places and their property in courthouses with nearly uncanny success. This is a book of consequence for historians of law broadly, be they scholars of Latin America, Africa, and Asia, or those across many US subfields, including African American, Native American, and women's history. So many of us are at work on the intersection of ordinary people and global markets, and we see our archives anew through this work. I do have a sort of, I don't know, rambly question for Laura Edwards, and I'll try it here and hope we'll get to it in discussion. And it really is about, and Laura, you'll recognize this question because it's not the first time I've asked it of you, about scale or the register of this work. On the one hand, those of us who know your work are not surprised how you render this history as profoundly intimate, right? Shaped by the rules and the logics that were local, so that we see how ordinary people's engagements with markets that were far flung actually played out on the ground and in lives. And on the other hand, there is that other scale. This is a history that plays out on a world scale across Europe, across Asia, across the Americas, knit together by movements, oceans, seas, and rivers. And I'm interested still in how you think about the choices of emphasis, how you help us sort of stay steady as we're asked and you demand of us to think in these varied frames. Folks will encounter those references to India and China and the Middle East that help us, I think, to anchor those kinds of questions. And for me, only the clothes on her back joins with scholars who have importantly taken the history of women in textiles in particular, beyond the history of labor, beyond the history of fashion and adornment, to find at least political, though I think path-breaking here is finding not only the political, but the legal meaning of those actions and transactions. I'm interested and intrigued by how Native American historians will also find their way to and into this book, thinking about Native America's own local legal cultures, yes, but the central role of textiles, textile making, fashioning, and more in Native American culture, and how they will figure here. So I think that's my time, but I do again want to say thank you to everybody for convenience, and especially thank you to Laura Edwards for this extraordinary book. It's really an honor to be here with you.
Thank you, Martha. Laura, would you like to respond to that question, that rather grand question that was just posed before we move on?
Sure. Scale. I had a really hard time with this book because on the one hand, I started researching in the South, thinking that a regional frame was the appropriate one. And then it became very clear that region did not explain what I was looking for. States did not explain what I was looking at, actually. And there was this weird, at least to me, thinking at that time, similarities between what was going on in like the New York City Mayor's Court, in Charleston, South Carolina, and South Carolina Upcountry, in North Carolina, in Pennsylvania. And it was strange to me because these were really very local jurisdictions that I was looking at, but the rules were operating when it came to textiles in a very similar way. And I was like scratching my head, I don't understand this. And yet it became clearer when I started thinking about the global textile market, and I started reading back in time and thinking about the way that, in fact, these goods had been moving across borders before there were even national borders, right? And that there's also there are legal principles that are developing in relationship to the goods that attach to the goods and start to travel with them. So I had to really think outside our usual framework for understanding law, right, and policy. We usually think within a national framework. And it was not the national framework that was operative here. It was actually a global market, global trade, and the principles that developed through those dynamics, and then that spread to people that people picked up and used. And so all of these legal principles kind of travel with the textiles themselves, but then they get a root down in local areas. People know them, but to make them work, it requires a lot of local knowledge. So you get the general principles, which is, along the lines of the things like clothing attaches to you. And if you have it, you probably own it. But then in order to figure that out, you have to go very local, because, which shirt belongs to which person is actually about a personal relationship to that particular item. So it is at once global and local. And then part of the story is this development of the state law, but then kind of a national legal culture based on rights that circulates across all of these local jurisdictions that starts developing and intervening with all of this as well. So I'm trying to handle all of those scales at once and keep the focus, on the textiles, but as they move around through these jurisdictions as well.
Thank you very much. Before we move on, just a reminder to those of you who are watching, you can participate as well. We have a number of people who have posed questions in the Q&A function, but you can also use the raise hand function, which has the advantage of I get to call on you, and if you unmute, you get to pose your question directly. So you can start getting in the queue now if you so desire. Just an FYI. Our second discussant this afternoon is Megan Sweeney, the Arthur F. Turneau Associate Professor of English, Afro-American and African Studies, and Women's and Gender Studies at the University of Michigan in Ann Arbor. She earned a BA in the History and Literatures of Religions from Northwestern University in 1989 and a PhD in Literature from Duke University in 2004. Her publications include an award-winning monograph, Reading is My Window, Books and the Art of Reading in Women's Prisons, published in 2010, an edited collection, The Story Within Us, Women Prisoners Reflect on Reading, 2012, and a collection of clothing-related lyric essays called Mendings, which is forthcoming from Duke University Press in 2023. At the University of Michigan, Megan Sweeney currently serves as Associate Chair and as Director of Graduate Studies in the Women's and Gender Studies program, as well as Director of Undergraduate Studies in the Department of English, Language, and Literature, and as Director of the Hopwood program. Megan, welcome to the Washington History Seminar.
Thank you so much, Eric, for that. And I just want to say it's such an honor for me to participate in this conversation with both of you, Laura and Martha. And I'm so grateful to have been brought together by this wonderful book. I remember when Martha first told me about you, Laura, and it's been so fun to dig into your work. As you say about yourself in your acknowledgements, Laura, textiles have always distracted me too. And I want to begin by sharing two quick anecdotes that came to mind as I was reading Only the Clothes on Her Back. First, in your acknowledgements, you reference Mulberry Silks in Carborough, North Carolina. I visited that shop about 35 years ago and keenly recall buying 1 yard of gorgeous fabric because that was all that I could afford, but I was determined to design and sew a shirt with that amount. Second, when my husband and I got married many years ago, my family gave us a spinning wheel and a loom as wedding gifts. And we signed up for a spinning class while we were in graduate school, but ended up having to drop the class because the spinning was so difficult and we didn't have time to practice. I created some very lumpy strands that broke about every 30 seconds. So I can attest to the considerable skill and dexterity and experience required for spinning. And I want to say hats off to the many spinners you honor in your book. In terms of comments and questions about Only the Clothes on Her Back, I'd like to dwell for a minute on broader dimensions of the book that I especially admire, and then get into some details with an observation and a few questions. Throughout my reading, I kept marveling at what a lucid, compelling, and lively account you offer of dense concepts and complex examples. I teach a course called Threads. What does clothing have to do with race, culture, politics, and the environment? And I'm so excited to incorporate more insights from your book into that course. I love your use of the weaving terms warp and weft to describe how people without strong claims to rights or property participated in constructing the country's legal fabric. If we think of the warp as the laws that restricted most Americans' legal status, and the weft as the textiles that people made legally meaningful. I love how you've organized each chapter around a particular historical case, paired with a central concept, such as currency, credit, or erasure. Those concepts provide such a helpful guide for readers. I love your manifest appreciation for the everyday textile artists confined to the margins of history, and your appreciation of their creations, which is evident when you describe, for instance, the rich details about preparing flax or fulling wool, or when you rest on the bit of ribbon or lace that's in the story. And I love the moments in which you dwell on the delightful language of the world you conjure, much of which is lost to us today. Alley-ballies, carry-derries, do-footies, gorgorons, hum-hums, and iseries. And I love, too, your flashes of wit and humor throughout the book, starting on the first page with your hopes that Elizabeth Billings donned more appropriate footwear for her attempted escape than the floral silk heels that she stole from her mistress. Before I ask my questions, I'd like to share one connection that I made in reading that I was really struck by. You draw attention to the insidious ways in which women's household production was devalued as merely domestic labor and was artificially and erroneously separated from market-oriented production. This point reminded me of a wonderful documentary called Angry Inuk, created by Alethea Arnacook-Burrell in 2016. The film focuses on efforts to ban commercial seal hunting, and those efforts have been absolutely devastating for Inuit people in the Canadian Arctic. Inuit women process and prepare the skins for sale in their homes, but their livelihood and the community's survival is totally dependent on the commercial trade in sealskins. So women's textile-related domestic work is part of the commercial market. But the Inuit are repeatedly told by activists that they are protected from negative effects of the ban by an exception that allows Inuits to hunt seals for personal use. The activists' refusal to recognize the imbrication of Inuit women's domestic and commercial work struck me as a contemporary version of the illegible nature of some women's commercial textile work that you describe so beautifully in your book. My first question has a long wind-up, so please bear with me. Throughout your book, you maintain a wonderful balance, I think, between, on the one hand, recognizing the concrete social, economic, and legal inequalities that shape the daily lives of those without strong claims to rights or property, and on the other hand, illuminating the creative, resourceful, and often very moving ways in which these ordinary people exercised agency in the midst of constraint. In terms of concrete limits, you remind us that textiles underwrote the slave trade. You emphasize, as you've mentioned today, that asserting property claims to textiles criminalized a huge range of property transactions as theft, that it was a fragile and fleeting form of agency that was unequally available to to those on the margins, given race and gender restrictions, and that it did nothing to challenge the foundational racial, gender, and class inequities of the social order. But at the same time, your book highlights so many savvy, important forms of quotidian agency, including, as one example, the subterfuge that people performed in accounting for time and labor that did not belong to them according to civil law, either by committing nothing to writing or, in examples that I loved, by tracking things in diaries or recipe books or commonplace books to prevent the property from being merged with a husband's property or an employer's property. And a second example, you talk about how women's quilting circles and sewing circles and dress fittings were as much about creating and maintaining property claims as they were about sociability or charity or the pooling of labor. Your account also unsettles and challenges so many ideas that have long seemed like givens, such as that married white women and enslaved people could not act as merchants or manufacturers, or that people on society's margins could never expect or demand recourse to the law, or that written codification of rights-based law represents unequivocal progress. And in unsettling these givens, you vividly evoke realities that seem quite distant or even unimaginable today, such as, and this is, I think, something that Martha was invoking, a concept of law as practice based in the customs of local communities and known widely by all, as opposed to our concept of law as universal principles based in the rights of individuals, which reside in books and is only available to the trained few. You emphasize the idea of local courts that had strong connections to the communities in which they were situated and that revolved around relationships. You emphasize the idea that public law incorporated those without rights into its basic workings because they were part of the public body. You emphasize the idea that relationships, a we, made it possible for individuals on the legal margins to act as an I who could make claims to property. You emphasize the idea of commercial transactions as matters of relationship instead of distanced exchanges removed from social contexts. And you emphasize the idea that most people paid keen attention to the intimate details of clothing and thought of long-lasting, well-made clothing as one of the most important forms of property investment. Here finally is my question. So keeping in mind your admirable refusal to romanticize the past that you conjure, I'm wondering if in the course of your research you ever found glimmers of possibility or food for thought that seemed helpful for reimagining some of our current givens. As a reader, I found it helpful and I dare say even hopeful to be reminded of that ideas that now seem immutable and irrefutable are time-bound and potentially ephemeral. So I found myself wondering what we might learn from the worlds you evoke in your book about contemporary possibilities for things like secondhand markets and exchanges, or local economies and mutual aid, or forms of local restorative, even transformative justice, or ways to wrest clothing from its participation in exploitative labor practices and environmental devastation. So I'm wondering, to what extent, if any, did you encounter ideas in your research that sparked your imagination about other ways that we might live in relation to clothing and also in relation to each other? So very long and winding question, but I hope it landed at a comprehensible place.
Laura?
And so, I have one more question too, but if it's helpful to go there first.
Sure. That's a huge question, Megan. What, my goodness, yes. This book is, I found other people in this book, I really liked them. And I found them puzzling, but I found them so incredibly admirable of their creativity, of the ways that they reimagined how they could work with the tools that they had. And in this instance, it's these, principles attached to textiles, but the textiles themselves, they kind of reimagined who they were through their material, the relationship to these material goods, and the ways that they could make these goods themselves too. It put not only legal agency, but economic agency in their hands in a way that I found refreshing, given the general presumptions that these people are kind of buffeted about by economic change and by, the laws of our country, which simply exploited them and gave them very little room for maneuver. What I found really fascinating was some of the things that you were pointing out with the we and I, this idea that, in fact, you had to have a group of people who could support you, that this was more important than this idea of an individual right for people who don't have power. And so this book really made me think very clearly and kind of critically in ways that I hadn't before about the difference between power and rights. I think that right now we tend to presume that if you have rights, you have power. And it was very clear from doing the research for this book that in this period, that if you had rights, sometimes that wasn't really very useful because you didn't have the power to use them. And in other instances, you just didn't have rights, but you could have considerable power, actually. So it made me separate these two things. And textiles was a way of rethinking this, right? So that, a wealthy woman who owned all kinds of clothing, but then all kinds of bed linens and textiles, she would have a group of people who knew that, who could, actually attach those goods to her. But without that group of people, those goods might move over into her husband's possessions because she was married to him. Coverture would place valuable property into the ambit of her husband's legal claims. But she needed that group of people around her to make sure that that property stayed with her. And this was even more important for enslaved women, for instance, and I have an example in the book, Polly, who actually has a small business of her own spinning thread. But people see Polly spinning the thread. They see her dyeing the thread. They know that it's her thread. All of those people who know that about her, they're able to help buttress her claims to this. So it's not her rights. It's the power that she has through those relationships. And it's this creation of we that is really important. This is also important for mothers and daughters. So we've seen people have hope chests. I knew this. My mother had a hope chest. Actually, my grandmother had a hope chest. Hope chests are full of like bed linens and other kinds of textiles usually. But hope chests we imagine is, those are the kinds of just the things that women get when they get married. And there's just, to help her set up the household and that's it. But actually, this is a transfer of capital from mothers to daughters. So mothers who often controlled the labor of their daughters would allow the daughters to claim the fruits of their own labor, what they produced in terms of textiles, or sometimes what they made in other kinds of productive activities, but then purchased textiles. They then put those textiles in trunks, which actually are legal containers to delimit property. And then the daughters had capital that they could keep in the marriage. So this is not just consumer goods. This is actually capital that they have that can take a woman through difficult times and would be also removed from her husband's creditors. It's like, oh my gosh, this is actually a we again of the mother, the daughter, and then people who know about this property, creating secure claims to this really valuable form of capital. So it's interesting for me to think about power that way rather than rights, but then think about power in creative ways too for today, right? Because we assume that rights will solve a whole range of problems in our society, but it may be that rights have less power to resolve those issues than this collective sense of these relationships we have to other people, this sense of communal action of the ideas of the public good, and the power that you can get through exactly those kinds of relationships that we may have vested too much in individuals and not seeing how all of those relationships and actually legal principles that attach to goods and that are created through those relationships, how important those are. So that was a long-winded answer to your question. And I think there are other things in here too that I find really interesting, like skill and the importance of skill and understanding value. But I'll leave it there and you ask your other question.
Thank you. Megan, back to you.
Wonderful, thank you. My second question has a much shorter windup, but it has two quick parts. As a non-historian, but in many ways a wannabe historian, I found myself thinking a lot about method as I was reading your book. And the first part of my question is, given the many silences and gaps in the archive, I'd love to hear more about when and how you realized that you had a new, different story to tell. How did the story coalesce for you, since so much of it goes against the grain of received wisdom? And the second part is, I'd love to hear more about how you taught yourself to read the extant materials, many of which require very different kinds of literacy. I'm thinking, for instance, of how Elizabeth Bagby recorded as memoranda the transactions related to textiles that she actually produced and traded, or how Rebecca Kate recorded her own work as a wife who did uncompensated domestic labor and also the wage work performed by her unmarried sister. How did you acquire the literacy for parsing these practices for what they were, given how little they have been visible in the record of explanation?
Yeah, so Elizabeth Bagby, for everybody else who hasn't read the book, Elizabeth Bagby has a memoranda book. Actually, it's called a memoranda book. It's called a commonplace book in the archives. It's not really a commonplace book. That's just what it's labeled. And she has all of her weaving accounts in this book. And at the beginning, though, she has a quote, and I'm going to forget the exact quote, but it's basically, for all the goods that belong to the household, you must keep careful account. But for the goods that you produce within yourself, and essentially the goods are going to belong to her, it's best to keep memoranda. And I looked at that, and I looked at that, and I looked at that, and I looked at that. And I looked at that for, I don't know, several years. And then I was like, oh my gosh, she's actually talking about household accounts, the goods that she produces as a wife under coverture that belong to her husband and their creditors. And then the memoranda is a way of separating out her goods. And so you have account books and you have accounts, because I have been looking at account books and puzzling over when women appear, when they don't appear, when enslaved people appear, when they don't appear. And it occurred to me, it's like, oh, those are legal records. Nobody uses account books in this period to like track economic production or figure out, how to better your business. It is a legal record to determine who's in debt to you and who's not, and how much they owe. So women don't appear in there because it's a legal form where it's unnecessary generally for married women to appear or enslaved people to appear, because you can't sue them in civil court, which is where like account books matter. Memoranda is something else. You take it in a different form. It looks different. The material qualities of it are different. And so it's a memoranda. It's not an account, which means that you've separated out your property and that the memoranda establishes your connection to it, but it doesn't give creditors, your husband or their creditors, any claim to that. And so, I don't know. It's these moments where you have this tension where something doesn't make sense. And it's those weird sentences. And that was one of them. It's like, best to keep a memoranda. I'm like, what does that mean? And then all of a sudden, we're sort of in the context of the larger like account book universe, it starts making more sense. And then once you get that little kind of clue there, so it's like, oh, then the whole chapter starts unfolding, or several of those chapters start unfolding with looking at how people do track their accounts. And they track accounts verbally, which have a different kind of legal resonance. They attract accounts through the material goods themselves. Like people would bring in, for instance, if he's accused of stealing a dress, and they bring in the dress and say, see, I didn't steal it. I'm like, why would you do that? That's not very like credible evidence to me. You could still bring in the stolen dress, right? But this is all part of a logic whereby if you are claiming like your connection to it and you're showing your connection to a material good, then that's a way of showing that you in fact do own it and have legal claim to it. You would never bring in something that you had stolen that you don't have legal claim to, because you would be hiding it and you would have actually like put it into the secondary market and got rid of it as fast as possible, right? To have claimed it, to have kept it, and then to wear it shows that you actually have this legal claim to it. So you have to start then piecing together the pieces of the evidence that don't make sense and then try to like create the pattern. So I always feel like this is a puzzle and you get little pieces of the puzzle and it's like, put this down. Oh, this is a corner piece, I think. Oh, it is a corner piece. And then all of a sudden other things start taking shape. And with this, it was really like seeing a world that I didn't know was there. And I found it really kind of exciting to piece together, for instance, the accounting and the ways that people are trying to hide their whole economic world, because if they put it in writing and put it in certain forms, it's going to move into the hands of their masters, their employers, their husbands, their fathers. And I found this particularly compelling with enslaved people who are constantly hiding the forms of accounting and yet constantly depending on all of those relationships of people seeing their goods. So it's utterly public, and yet we can no longer see it as historians because the evidence was kept in a way that is not saved and not visible, and for a reason, right? So we have all of the written evidence of the economic world of the men with property who could work in civil law because that is in writing and it was saved in particular kinds of forms that now are in archives. And so we think that's the only thing. And yet there's this whole other world out there that was documented in very different ways. And we don't see that anymore. To me, that gets back to your first question too. It's like, there's a whole world there that we're unaware of that we could still draw on, because the possibilities to imagine economic exchange, power, people's relationship to law, it's much broader in our past than what we had assumed.
Thank you. It's wonderful.
Thank you. We're now going to open this up to those in the audience. We have a hand patiently waiting to be called upon. Sonia Michelle, you know the routine. Please unmute, join the conversation.
Thank you, Eric, and thank you very much, Laura, for what sounds like a fascinating book. I ordered it while you were talking. Sorry, I missed the first few minutes, but I ordered it as soon as I heard you talking about it. First of all, just let me start with a little anecdote. Perhaps you read in the New York Times last week, there was an article about the Ukrainian Air Force, and there was one line that struck me where they described the wife of one of the pilots, and he said, and the article said, she spends her days weaving homemade camouflage nets for the Ukrainian army. And that phrase was just so incredibly evocative. I don't know if you know, I've abandoned history and I'm now become an artist, and I immediately started working on a collage that evoked to me what the camouflage nets must look like, these homemade camouflage nets. But I do have a question, or a sort of series of questions. And I'm sorry, I didn't hear the sort of a whole overview of your book, so maybe you'd already touched on this. But what is the relationship between, throughout the 19th century, textile production, weaving, and so forth was becoming increasingly industrialized. And I wonder if that's a thread or a theme through the book, and if so, how that relates to this, what obviously seems to be another focus of yours, that is the individual and handmade production of textiles. And then sort of going in a somewhat different direction, I was doing the wash this morning and I was thinking about laundry. What is the relationship between laundry, textile production and laundry on the one hand, and textile production and women's dressmaking and tailoring on the other, and the sort of gendering of all of those activities? I wonder if you talk about all of that in the book.
Yeah, so let me do laundry first. Laundering is how you rehabilitate textiles. So, and laundering is really important because as actually Megan, I believe, was saying, it's like having well-made, fitted clothes that are well kept. It's like, this is really important to people. This is not just sort of like poor people do this because it's really meaningful to them. They're not doing it simply to, to try to aspire to middle-class values or anything. This is something that is incredibly important because it is supposed to, clothing represents your inner self. It is your inner self is expressed through your outer layers. And so this is about making a statement about your character. And it is seen as really important to like tend to that. And so it's not just a matter of having expensive clothing, it's a matter of keeping it up and making sure it's well fitted and well tended. And so laundry is a part of that. And poor people go to extraordinary lengths to launder their clothes and to have white linen in particular. Kathleen Brown has written about this. John Stiles has written about this. But laundering is also about adding value, right? So if you think about the metaphors and the imagery here, it's like money laundering, you make it clean, but you can make clothing clean and you launder it and you turn it into a better version of itself. You're adding value that way. And I found it really fascinating to think about the production of clothing, laundering, but also all the kinds of mending and then remaking of clothes that people do. They're constantly adding value to this stuff. And so it's not just making it prettier. It is, in fact, making this into a more valuable item. And then that's part of adding value and like exchanging it and turning it into currency as well. So I feel like people are kind of printing money in some ways when they're doing this. And that part we've never really kind of considered. I find that to be fascinating. So the industrialization part, that's the storyline is that I was raised on, and that I think is still kind of central to the literature, is that the early 19th century, you get the mechanization of cotton production and weaving and spinning, and you get the Lowell mills, and then it all is basically industrialized. And the focus then is on people who work in the mills, with the presumption that basically mechanization is taking over the whole situation here when textile production. But then I started looking at it, and it's actually way more complicated than that. So textiles are unevenly mechanized. So cotton is mechanized. Wool is much harder to mechanize, although it is mechanized faster. Linen isn't really mechanized until in the late 19th, early 20th century. And silk is also, the weaving of it becomes mechanized, but still the making of silk is actually really difficult. And the weaving of it is difficult too. It's more moderately mechanized. So there are all sorts of spaces in this economy for hand labor, especially with linen production, with wool. The best wool is still done by hand. And cotton production is also, a lot of really fine cottons are still done by hand because the stuff that machines do isn't that great at first. And then the more stuff you produce, the more opportunities there are to fashion it into clothing, which actually produces more hand labor. And so you find a lot of hand labor, like in the Delaware River Valley, for instance, that is growing up alongside factory labor. And this gets to that, skills and value. And even then, if you're working in a factory, skills still matter. So it's not like anybody can walk in there and do it. Although somehow we tend to presume that in the same way that we kind of presume, well, anybody can sew stuff, right? All women could do that. It's like, no, it actually takes a lot of skill. And like really good cloth, if it's well done, that's what makes it commercially viable. So, and before mechanization, basically all cloth is done in the household. And what distinguishes homespun from commercial cloth is the quality. And the quality is not something that is determined by gender. Women can produce quality. Poor people can produce quality. It has nothing to do with race either. It has to do with somebody's skills. So women and, enslaved people, free Blacks, all these people are concentrating oftentimes in textile hand production and also mechanized textile production too, but textile hand production because they can basically create value with their hands, but they can also keep the value with their hands. And so I find this to be really important, right? We've missed this key part of the whole explanation as to why these things are gendered, but I would argue also raced too, because in fact, out of all the things that you can produce, out of all of your very bad options, if you are a woman, a poor person, or a person of color in this period, textile production actually provides you a way to keep at least some of what you produce and legally. And this is really important. So for instance, I have these letters that were in Duke University manuscripts, archives, and they're from women who in the 1840s were working in Lowell mills. They turn all of their wages into fabric. And I find this fascinating, right? So they buy fabric, they can buy it in Lowell, and it's a good deal relative to where they live. They then go home and sell it. And there's all this correspondence back and forth between the sisters. It's like, don't tell people how much it cost at Lowell because they want to charge more back at home, right? And then they have all this other kinds of, directives, as in, I'm sending you, this long cut of cloth. Don't cut it up. Don't cut it up to sell it. That will devalue it. And so they're very aware here of what kinds of goods they can produce, but then also what kinds of value they can claim. All of those women are actually unmarried, but the connection of women and textiles is so close that, the idea that, oh, if you're a woman, textiles is the thing you do and you trade in, that has become really ingrained by that point. So yeah, I think that piece of it is really important for understanding industrialization, but then also seeing how industrialization actually increases the spaces and opportunities for skilled hand labor too.
Thank you. Michael Novak, you've got a hand up. Please join us.
Can you hear me?
Yes, we can.
Okay, good afternoon. Thank you for being here. My question is, you're talking a lot about the manufacturing of cloth and textiles and how it relates to people's role in the law and the economy. I was wondering if this is related in any way, if you've looked into the making of shoes and if that was similar, if it was totally different. I don't know if you've looked at that. I'm just curious if you found anything interesting.
Yeah, I don't actually look into the making of shoes, but people claim shoes that kind of include shoes in the textile rubric, which I find fascinating. I think this relates to some of what Martha was talking about. These people they're very creative, and it's like textiles. Clothing belongs to me, but handkerchiefs belong to me too, and hats, and scarves, and shoes too. So, basically after a certain point, it's like, well, if it has something to do with textiles, feathers are for hats, right? If it passes through my hands, I own it. So it's not just the clothing you wear, it's all this other stuff. And so all of the accessories get included in, or people try to include them in, and they're fairly successful in doing so, although not always, right? So they include all those in there. And so that's kind of why I have this, people always ask me, what are textiles? It's like, well, basically it's a legal category. It's all the goods that you can include within this category. And this category sort of extends out to include shoes. There is one great case with shoes where there's an enslaved man who has a solid business dealing in dry goods to other enslaved people in his community. And he is accused of stealing shoes. And I think this also gets back to this question of I and we. And so what he does is he brings out all of the enslaved customers who shop with him, essentially. And he has a store it's a store of goods, not an actual physical place. And so he brings out all of these witnesses who one lines up and says, no, the shoes that you say were stolen, he didn't have them because the shoes he was selling, those shoes are really poor quality. And I was looking for like better shoes. And so, he's saying, no, those weren't the shoes that he had, and we have another person line up and say, no, there's something else going on here. There was actually a fight about. So this, as they're all testifying about the goods that this man has and the fact that he has goods and is selling to other enslaved people as a way then of saying that, no, he didn't actually steal the goods. It's really fascinating because, in fact, they all could have been arrested for he could be arrested for dealing goods with enslaved people he's not supposed to be selling. But all of that became evidence of the fact that he didn't steal the shoes in question because other people saw him with a whole different array of goods, but not those shoes. So again, it was the way that he was dealing, all the people surrounding him who were then able to ultimately save him from that theft charge. And it was also interesting that the magistrates didn't really care that he was like selling shoes and other dry goods in the secondary market. They were more concerned with theft, but the presumption was he could make some sort of legal claims to those goods. And in fact, so much so that he could even engage in selling them. So.
Thank you. Up next, Leon Fink, and then if Ursula Rack could stand by, we'll call on you after Leon.
Hey, Laura.
Hey, Leon.
Hear this account of what I'm sure is a great book.
Leon? I think we've lost you.
I was intrigued by your response to Sonia Michelle's. Oh, hello. Hello. Can you hear me?
Leon? Yes,
Can you hear me? Sorry.
now we can.
Okay. I don't know what the problem is. In any case, I was interested in the relationship, Laura, between the world that you're describing of basically home-based textile production and the industrial world of production that we're more familiar with, at least as labor historians are. And I was interested in your suggestion that there's maybe an interaction between these two worlds, but one distinction seems to be that at least is in the methods of attending to grievances. In your world, it seems to be an individual and legal arena. In the more industrial centers, it's history, from Lowell through Amiskey through the southern mills, seems to be a more collective form of address. Could you comment on that distinction and what you think might be the interactions? And you think there's a whole world of labor history that might, for example, even among industrial textile workers who might at the same time be involved not only in home production, but also in legal complaints that we haven't really examined yet?
Yeah, I was really struck. I mean, I was, like I said, raised on that distinction between you have the household production, you have the industrial production, and yet a lot of the work in textile and textile history is blurring all those distinctions by pushing at least commercialization, but also the transformation of labor relations, not just commercialization, back in time and putting that actually within households. So you have the putting out system, you have the breakup of kind of independent producers and having them lumped under, somebody who's a merchant who's then organizing production and skimming, from the top of basically they become wage workers, but working in their households and often relying on household labor of women and children. So all of that is happening within households, but then those people sort of move into industry, into factories. But that transition, I don't think is as abrupt as what we've imagined. And some of the people who are coming to the United States are like, they're refugees from the linen industry in the British Isles and the woolen industry too in the British Isles. And so they're trying to get away from that system, but they're also relying on the skills then to set up shop in their own homes. And often the women are the ones who are taking over that kind of labor. But then it's an easy sort of transition into some of these factory settings where it's not quite as abrupt as you see in cotton. So you would have wool factories where you might be working in the factory, but you're kind of doing the same thing you would be doing at home. And some wool factories are actually putting out systems. So Seth Rockman's work is really interesting in this regard. But then I think your question about communal approaches, I think you're getting the wrong impression if you think I'm saying that these are individual and individualistic claims. I mean, that would be the kind of the gloss that civil law puts on this, where you're framed, the legal framework casts you as an individual with rights who then makes claims against another individual. This is taking place. And even then, actually, a lot of, and I'm hoping the book underscores this, even then, that's a legal frame. And in fact, all of that depends on a whole bunch of evidence that is involved with it. It depends on other people knowing about your property claims and being able to come and justify that and support you and all of that. So there is usually a community behind any sort of legal claim to property. But then if you look in the public side that I'm talking about, where people are making claims to property without rights, you come in with your whole crew. It's what Sarah Allingham did. It actually is what Sarah Allingham didn't do. It's what Rosanna Marara did. So she comes in with her sheet and her witnesses, and all these people come in, and you've got to have all those folks. And so there is a sense of community and collaboration in there, of understanding what certain, principles are in your community, what sort of practices are accepted, and then it's a constant effort of enforcement, which involves a whole range of people. And if you think about it, that's not so different from what's going on in mills, where like you have certain expectations about workplace practices, about value of your labor, about the relationships you have with the people who are employing you. And then there's collective action around that. You're just going to get more collective action because you're all lumped together in that factory, right? But you find the same kinds of expectations with the enforcement of the practices surrounding the exchange and ownership of textiles generally. So I don't think they're as dissimilar. Actually, I think there's overlap there. And I think that the framework, as I said earlier, like the rights-based framework, it's a legal framework. And to mistake that with how things actually work is to like mix those things up. I mean, the legal framework is not social, how so people think about property, it's how the legal framework handles that. And people slot their issues into that framework. And sometimes that framework is really important in the way that people start imagining things, but it's entirely different from the way people actually operate oftentimes.
Thank you. Ursula Rack, you've been patiently waiting. Please join us if you unmute.
Hello, good morning from New Zealand. I'm a historian myself. I was wondering, how was it with men's clothing, especially when they were younger and you know, sons? But what happened, for example, with the clothes when the husband or father or the owner of the woman died? How was that working? Was the clothes from the men also then in the possession of the women, or was only women's clothes and bed linen and so on her property? Thank you.
So yeah, the clothes that belong to the person belong to the person. So it's kind of, it's not presumed then that the like a husband's clothes would then move to the wife. And people are very particular about their clothes. So, you know, like men are really particular about their clothes too. And their wives are not, their wives will like, and this is kind of well established in scholarship that I did not do, that wives are responsible for linens basically, but men are like their coats and their pants, they go off and do that themselves. And I have a group of women, coolie women who have in Western Virginia, who have a whole business and they sew, they weave, they do a bunch of different kinds of things all in textile production. But one of the sort of key customer bases is men who want really fancy coats for militia musters. And this is a thing. So you have a uniform, which is not actually uniform. It is a uniform, but there's nothing uniform about it. I also think that's kind of fascinating, actually. So they all come with sort of the same style, but different colors, and they want braids, and they want epaulets, and they want, you know, buckets, and they need little trimmings over here. And so they do this, you know, they do the coats, and the guys are really picky about what it looks like, and they come in for fittings, and they want, oh, it's just great. So there is this real attachment of people to, you know, the clothes that they wear that way. And so within families, yes, it's the children's clothes are theirs, the wives' clothes are theirs, and then the other textiles that they're able to kind of account for in their community, and the community knows that they're theirs. So there's this constant sort of sorting around that way. But yes, the men's clothes don't automatically go to the wife. The wife does not automatically own everything that's in the household. It is, she has to establish those claims, just to work really hard to establish those claims.
Thank you. We have a question in the Q&A. Her hand also went up, but then it went down. So at least I have the question, and I will pose it on behalf of Kyra Haynes, who writes, as someone who is doing their senior thesis on Victorian fashion, could you talk about your research process and what it was like, and what sources you relied upon for your research?
So this is where Martha has like listened to me talk about this research forever and ever. And the research process was long and arduous. I feel like I was doing this when I didn't know I was doing it. So I started kind of like collecting stuff about textiles when I was doing my dissertation, which had nothing to do with textiles. I just got distracted by it. So I've been collecting this for a very long time, and I didn't really see how it all fit together until or how I was going to fit together until recently. But I've looked at court cases, local court cases. I've looked at federal court cases. I've looked at state court cases. I've looked at account books. I've looked at correspondence about clothing. This is not the kind of book that I looked at the material artifacts themselves. And so this is not really the kind of book that I could have done early in my career. I feel like history, you're very privileged to accumulate things over time, and you're able to have these longer term projects. And this is definitely one of those. If I had just, and I actually had a crisis of conscience and faith, or I don't know, method maybe would be a better way to put it, when I was doing footnotes for an article recently. And they said, I cited a collection of court cases, and they said, no, we need specific court cases that prove this point. And the point I was making was about the legal qualities of trunks. So trunks are a legal container for people who don't own their own houses. And so I had tons of cases on trunks, hundreds of cases on trunks, and I didn't know what trunks meant. And then one day it occurred to me, as I was looking at the hundreds of cases on trunks, that people were referring to trunks as a way to demarcate the property as theirs, and it had definite legal qualities. And in fact, you could get search warrants for trunks, for instance. So I was stuck because I'm like, am I supposed to cite the several hundred cases on trunks that I have? Because if you look at any one case, you don't see the point. It would just refer to a trunk, and you would walk by that case like I had walked by those cases. It was just that I happened to make notes about trunks because, I don't know, I was like doing something verbatim, like transcription of the court record. So I didn't know what to do exactly, because this is through practice and it's through repetition of these things. And so this gets, I think, to Megan's question about method. It's like, you have to look at this for a very long time, and you have to look at it over and over and over and over. And this is also, I think, what, Martha's comment too is about. It's like, this is about practice. The way that it becomes law is that if you do it over and over and over and over. So it makes it really difficult to explain citations to folks, because they're expecting the court case that establishes the principle. And there's no one court case that does that in this instance. It's just the repetition. And so you kind of have to hang in there long enough to get the repetition and persistent. So this works for me. But that's kind of difficult if you're like doing a senior thesis, for instance. You don't have the time to do that.
But if you could just elaborate a little bit more. So you've had many years of experience with these records and the issues that you're dealing with. And so this is in the back of your mind, it stays there, and that allows you to see eventually things that you didn't see before.
Right.
You used a terrific phrase, seeing a world that I didn't know was there. And I love that phrasing. But as a legal historian who is interested both in the law, but in the real people and the social relations that the law can help illuminate, it's safe to say that your diving into the world of legal cases allows you to recreate that kind of broader social world and the dynamic and the relationships between people. So these cases are about more than principle and outcomes, but they do allow you to see and then reconstitute this world that you didn't know was there.
Yeah, and it's like I said, it's true. Yes, and it's true. But if you look at like local court cases, and Martha, feel free to weigh in here on local court cases. It's like you get little fragments. It's like I have a paragraph, and it will say, so-and-so Ellen stole something out of Sue's trunk, and Sue said it was in her. She hadn't closed the lid. And I'm like, what is this about? So you have then another case, it's about somebody else stole something, it's a list of stuff from a trunk, and you get another little phrase. You don't get much though. So it is about the repetition. And so like, for instance, with trunks, I realized through repetition that if you keep the lid open, then you've not reduced what's in the trunk to your possession. This is important if you're enslaved or a servant in a house, because you could be accused of stealing something of your master's and mistress's if it was found in the trunk. But then you say the lid was open, so you hadn't reduced it to your possession. If you close the lid, then you're in like territory there where you've claimed the goods as your own because you've closed the lid. It's still gray though, because you just closed it. You could open it back up, which means that your master or mistress could come back in and then take whatever it is that they're accused of stealing out of the trunk. If you close the lid and lock it, then you've reduced this to your possession because you've made it so that this is a container that nobody else can get into. Understanding that though took me like hundreds of cases to figure it out, right? So, and there's no one case that says, aha, the principle of the open trunk lid. And so it is, those legal cases, the local cases in particular, are, you just have to handle them differently than you would like a state or federal case where they are dealing with a principle of law. And the point is to state that. And here they're like, they're not. And they're hiding this from you, kind of. Martha, you could weigh in on this too, I think.
Well, I guess I could just push us a little bit, to say that, what I think I've learned from you, but I don't want to speak for you, but what I've taken from your work is the mistake we make is thinking that what law is text, that law is doctrine, that law is the Constitution, that law is the common law as it is articulated and iterated over time. That is not law. That law requires, for historians, yes, an understanding of the text, but ultimately the history of law is what people do with the text, and how people in their practices produce the text. And that is, so it's to say that the distinction as if somehow there's law and then sort of mixing with law is something like, I don't know, social or cultural, political history is sort of misses, I think, the intervention, because the intervention is to say that's a false distinction, and that actually the history of law is the history of how parties, people, societies, and more make meaning, and how meaning changes over time, how meaning is produced over time. So maybe I've overstated it, Laura, but that's a way to just sort of force the point, I guess.
Yeah, thanks, Martha. That is, thank you. And yes, and part of the point of this book too is to show kind of changes in that over time, because we kind of take the institutional history of courts for granted. We kind of assume that there is this thing, law, and it works in a certain way. And, you got the higher courts, you got the lower courts, and it's always like that. And part of this is to mess with people's heads about this, to change our understanding of this history. And so like a whole chapter on overlapping jurisdictions and overlapping bodies of law in the decades following the revolution. And so it's even more important in the late 18th and early 19th century in the United States, where there are different jurisdictions, where there are different bodies of law, where there is less coordination of all of that. And so there is also a real sense that you can create principles through practice. And so as Martha was saying, it's not that this is practice and somehow then we have law over here. It's that the principles you can see and create through the practice, and those principles have as much kind of legal traction as what is in a written text. And over the course of this period, though, you also do see that certain elements of written text acquire more traction and more power and authority within the legal system. And those tend to be about rights-based laws, based where you get more about procedure. So for instance, in local court cases with all the women who bring in their textiles and say, look, and I bought it here and I did this and I'm wearing it and you understand, all of that starts giving way to more procedural based cases, or cases based on procedural rights. So the questions would be more about, well, was the door locked or not? Because that would be about whether it's breaking and entering or whether they just entered. And you get this more sort of formalized rights-based system that starts inflecting a lot of these local cases. And the written law and particular kinds of written laws that are taught in law schools that are then elevated in this period as being the primary source of law, that's part of the, the developments that are happening as well. So, the reason why we go there is because of this period where that kind of law acquires more meaning and authority and starts taking up more space. And people start arguing that the written texts are actually really more important than the practices themselves. And we've forgotten then that those practices used to have real legal traction. And they still do in a lot of ways, because even to this day, Brown v. Board of Education is a great example. It's about practice. People are constantly in Supreme Court cases talking about, US Supreme Court cases talking about practice, history, what used to be. Originalism is in fact about, this idea about what the practices actually were in the past. So we still also give practice a lot of space in law, and we don't always, I think, recognize that, but we don't see the real space it had in the 19th century, and we don't see it as creating law in the way that it did in that period.
Thank you. You tell many stories in the book, a very diverse set of characters. You end the book with perhaps the best known name of Mary Todd Lincoln. If you could just say just a few words about that example and what it reveals and how and why you end the book with her experience.
Yeah, it was a real revelation for me that Mary Todd Lincoln produced a national crisis by trying to sell her clothes that she wore while she was, the president's wife. I'm like, wow. So this to me is this example of how clothing loses its legal valence and becomes more like simply a consumer item. And if it's a consumer item that is simply your second skin, and especially in the post-emancipation period, to sell your second skin is akin to selling yourself. And this is the way that then, Mary Todd Lincoln is just completely ridiculed in the national press for, she's in such bad taste. She's selling herself. She's like a prostitute. And in fact, women had always sold their clothes. This was their capital. This is what they have entire secondhand clothing stores set up on most main streets in America to handle exactly this kind of thing. And yet it is cast in a very different way as a consumer good, not something that is legally legible and legally important for people to do. And the real important part of this as well is that caught in the midst of all of this is Elizabeth Keckley, who is Mary Todd Lincoln's modiste. And she has an entire business set up, which is not just being a seamstress, but it is designing and fashioning clothing and making it for, Washington's elite women. So her carefully designed garments are then held up for ridicule by the entire country. And then basically all of the labor and the skill that was brought into that is also erased as these goods become simply consumer goods. Why would you sell your old clothes? Just go buy new ones. Who has old clothes anyway? And she never recovered, Elizabeth Keckley. She didn't get her business back. It was this erasure of her skill, and also the legal qualities of clothing too, that, made them actually forms the currency and capital that women sold all the time, and the poor people, enslaved people had sold all the time. And so it is this really sad ending to the story too, because, this is post-emancipation period. This is when we're going to enact the 14th Amendment. Nobody gets rid of coverture at that point. Married Women's Property Acts do not get rid of coverture. And Elizabeth Keckley is going to be in a very different position than African-American men in this period. And then even then, African-American men, while they do, it's like Dylan Penningroth's new book is going to be about all this, there still is a lot of ability for African-Americans to claim property, but we've not fully considered the ways that men and women's relationship to property is very different based on the different trajectory of the extension of rights, but then also the erasure of these other ways of claiming property. And Megan, this may get back to your point as well, is that we're so accustomed to thinking of property as an individual possession that we also can't imagine different ways of owning, using, regulating property, that it could be for the public good, that it could be about communities of people, that there are different ways of making claims on the productive capacity of that property too, beyond simply those of individuals and absolute ownership that we imagine today. So.
Thank you. I unfortunately have to draw this to a close because our designated time is up. But I do want to express my sincere thanks to Laura, Martha, and Megan for this great conversation. And I would also invite everyone back next Monday on April 11th at 4 p.m. when the Washington History Seminar returns for a session on a just published book by Gary Gerstle entitled The Rise and Fall of the Neoliberal Order, America and the World in the Free Market Era, with discussants Elizabeth Cohen and Christina Spohr. And with that, I can say we hope to see you next week. Till then, take care, be safe, good night, and thank you, everyone.